I know our HR team has been in contact with most of you or all of you. Please continue to reach out to us. You reach out to me directly. We're going to get through this together. I know we are, but it's a tough situation. It's an evolving situation. And the problem is, we just don't know what the end looks like. But again, we're here for you guys, whether it be from a personal perspective or a business perspective. This is affecting all of us, whether it be health-wise or business-wise. So it's a kind of a double-edged sword here. But I'm confident we'll make it through it. But it's going to be some tough times, and working together, I think we'll figure this out. So again, to just go ahead and move on, I'm going to introduce Carlos Umpano and Kelly, who are outside counsel, who have been great at putting together a presentation for all of us on the information we've got today. But again, information is fluid, it's changing all the time, and we will continue to maintain you guys updated as much as possible. There will be some time for questions at the end. I think there's a place where you can enter questions as the presentation is going on. Feel free to do that. And like I said, feel free to reach out to any of our people, whether it be your HR manager, myself, your payroll reps. We're all available 24/7. And like I said, we will get through this. Thank you all very much again for joining us, and I'll let Carlos and Kelly take over.
Thank you, Carlos. I appreciate it, and I can't echo and thank you for your words of encouragement. This is a tough time for everybody, and it's important to understand from a big picture standpoint what's going on in the world. And we thank Regis for the opportunity to discuss these issues with you all today and go through them. So thank you again, Carlos, for your words of encouragement. So let's talk about what's going on big picture. This presentation is going to be divided up.
We lost
Are we connected? Carlos, can you hear us?
Yes, I can. Carlos, you need to share your screen.
But we lost our.
Elise, we just lost the connection. How do you want us to reshare it?
Let me.
It was on a second ago.
Okay, let me take it back. Okay, perfect. We can see your screen now.
Okay, wonderful. Thank you, Elise. So in short, despite these difficult times, it's important to stay abreast of everything that's going on.
We see the one. We see the screen with the web browser.
Okay.
You don't see.
Elise, I think you got the wrong screen. You want to try and switch it?
Sure.
I have. You don't see me flipping through?
No, I see the one with the web browser.
All right, let's try and switch it back to the other screen.
All right.
Hold on. Let me.
Okay.
What's happening?
Share. Elise, are you coming in to switch it?
Yep, you should be able to select it now.
Okay, screen right here. Select this right here. Screen. That's it.
Screen of monitor too.
Yep.
Sure.
Okay, can you see it now?
Yep, we got it.
All right, wonderful. Okay, great. So a lot's going on, as you all can see and hear from the media, but it's important to stay focused during this time. As Carlos has stated, a lot's going on, and we're here to help get through this, and we thank Regis for the opportunity to present today. So what we're going to do is do a presentation. It should be about an hour long, plus or minus, and it's going to go through some meat and potatoes of what exactly is out there now. We want to get to the crux of what we're dealing with on the House bill and a bunch of other issues that may affect you as an employer from a day-to-day basis. So I'm here with Kelly Cueto, and we're going to start presenting. We're going to be providing some guidance for employers from a big picture standpoint. 4 topics that we're going to get into today are going to be operational concerns as an employer. You're going to see a theme that is very common is communication. Communication is key amongst management, amongst employees, and amongst each other. It's going to be very, very key during these trying times. Part 2 is going to go into an analysis of legal requirements versus best practices. This is where we're going to get into the current House bill that is pending, that is going before the Senate as we speak, that has not been voted on. But I think it's going to be a good base framework to work from even though there are likely to be changes, let's get ahead of the game and understand what's in that bill and how it affects you as employers. Part 3, we're going to get into some specific HR concerns, and we're going to talk about the importance of consistency, which is already out there in the expectation from the FLSA and the Department of Labor. And we're going to go through how you can manage through the legal aspects of these HR concerns. And then in part 4, we're going to get into a question and answer session. We have a list of questions, and we went ahead and put the answers in there on some of the more common questions that we're hearing as attorneys out there and that Regis is hearing as a PEO, and we'll answer all of those, and then we can try and open it up later to some question and answers if we have enough time. So why don't we start with the first part, operational concern. Communication is key. I'm going to turn over to Kelly.
Great, thanks, Carlos. So we have been kind of monitoring this and taking questions on this from our clients and from you all as Regis clients for probably about 2 months now at this point in terms of what can we do to get ahead of this thing. And so this is not new, but all of a sudden it seems to have spiraled out of control. So here we are, and these are, in terms of communication, the things that you've probably already thought about, perhaps have already taken care of. So I don't want to spend too much time on them because I know that what you really want to see is the Q&A. So from the disease itself perspective and the CDC guidelines, we are not doctors, so we won't go through the medical epidemiology here. We would say that you are likely not doctors either, although some of you may be. But we do not recommend doing anything other than referring your employees to the information about the disease directly to the CDC guidelines. Don't take information that you see on Facebook or that your Aunt Susie told you that she heard from her friend and share that in the workplace. That's not going to be helpful, and that's not something that you want to do in and among your employees. So refer back to the CDC guidelines. Communications to your employees and your clients need to be consistent. You don't want to be communicating information about your business or your business operations out to your clients before you communicate them to your employees. Just something from an operational perspective to keep in mind. You don't want your employees to find out that you're going to be making an operational decision from a client as opposed to from you directly. If you are in an industry where you can engage in remote work or telework or anything like that, you want to make sure that you've got your IT consultation and infrastructure set up to do that, and that you've tested that structure. From a policy perspective, if you have not done it recently or already with respect to coronavirus, you are going to want to take a look at those policies, perhaps on your own, perhaps in conjunction with your Regis HR manager, both your general policies and perhaps particularly here in South Florida, you might have a hurricane disaster preparedness plan to look to see if anything from that can be utilized with respect to this virus, if there is a business shutdown and how to recover from that. To the extent you want to update any of those policies, now would be the time to do it. And then there's also contingency planning and testing. So, to the extent, like I said, if you are thinking about a remote work plan, test the system, send everybody home for a day and have them all try to log on at once. Does your infrastructure support that? Trying to do something else like, if your business does not support a fully at home setup, are there other options for you? A lot of clients are looking at these 50-50 plans where 50% of the workforce is working from home or perhaps not working for 2 weeks while the other 50% is working in the office, and then they flip with 50% out for 2 weeks and the other 50% back in. The 2 weeks seems to be a pretty good standard given not just a business operations perspective, but also the the incubation period for the virus is 14 days, so it protects employees from a health perspective as well.
And we'll get into this more in detail as we go through the presentation. So let's go to part 2, legal requirements versus best practices. And flexibility is key here. Let's start with where we are from a big picture standpoint. Currently, there is no act, there is no law in place that is changing most of the laws that you're currently subject to. The House has passed a bill, but it's not in effect and it's not binding on companies or businesses until the Senate approves it and the president signs off on it. So currently, you have legal requirements that's status quo. You still need to conduct your business currently under the ADA, FMLA, FLSA. You've got to continue to pay the minimum wage, exempt versus non-exempt. Those classifications all remain. OSHA requirements, those remain the same. Warn for group layoffs, so we'll get into that a little bit further down. All those notice provisions and when they're and how they're applicable remain the same. Older Worker Benefits Protection Act. If you're looking to do a group layoff, which is a termination of more than one employee as a result of restructuring, for instance, and you want to get releases and severances, there are disclosures you still have to abide by. Title VII, non-discrimination. All of those laws are still in effect and they have not been changed. So continue to consult with Regis for HR matters in connection with all of those laws and HR related issues, and they'll elevate you to counsel as needed. But govern yourselves currently under the existing laws. However, in a very short period of time, this is likely to change, at least when it comes to issues that we're about to get into, such as expanded FMLA, required paid sick leave, and how all of these new laws, unemployment insurance, how these new laws are coming down the pipe and how they'll affect you as a business. But if they're not addressed in the House Act and they're not addressed in a special state law, then the current status quo applies. So we're going to turn a little bit here and talk to you about changes that are going on. We'll give you some examples and then focus a big part of this discussion on the House Act that has presently passed the House and is currently before the Senate and likely to be tweaked. So there are new state and federal proposed laws. There are some state laws that have preempted the federal law. They have, in fact, for instance, Colorado has already gone and passed the 4-day paid sick leave as an emergency paid sick leave law. So there are specific states and jurisdictions that are quickly moving the goalpost, even though the federal government is still in discussions. Florida, however, has not mandated paid sick leave, for instance. Colorado has. Florida usually follows the federal guidelines and laws, and they like to stick to implementing the federal laws and regulations as opposed to going outside the box and being a little bit more aggressive in the federal level. You might see that change in this extraordinary circumstance, but for now, for instance, as to paid sick leave, it's very different if you live in Florida versus Colorado.
Right. And actually, in between the time we put this presentation together and presented it actually this morning at 10 o'clock and presented it now again at 2, we did get notification that the governor of New York has proposed legislation on the books for an additional New York paid sick leave that is looked at as another stopgap measure similar to Colorado. We'll see more and more of these coming out where states are looking to protect their own state employees or employees in those particular states. I don't want it to sound like it's government employees only. So employees living in those states until the government actually acts. New York is a little bit different because theirs is written such that if their program that they put in place or their law that they put in place is more generous than the federal law, and the New York law is going to apply. Or if there's a difference, then they're going to offset and the employee is actually going to get the difference from New York. So it's going to be kind of a mishmash, and until federal legislation is passed, look to see the states pass these laws kind of ad hoc until the federal government acts.
And some of them are quite interesting. The Colorado one that just passed is 4 days, and it's to keep employees out of the workplace, at least during testing. And it remains in effect for 30 days or longer, but that depends on the emergency declaration. So you're going to be seeing state and federal work closely with each other as the federal takes the lead and try and implement a nationwide passage here. All right, so let's get into the FMLA expansion under the current law, HR 6201. four main areas that we're going to briefly go through. FMLA expansion, forced required paid sick leave, expanded unemployment insurance, and tax credits. Those are four areas that most businesses are looking at very, very closely, aside from other benefits such as insurance companies not charging for coronavirus testing and things of that nature, which are ancillary. But in terms of the day-to-day management of your business, these are four areas that many businesses are looking at very closely because it will impact them directly. So let's start with the FMLA expansion as proposed by the House, currently being reviewed by the Senate. It would take effect 15 days after signing. This would sunset, it would terminate at this time all the way up until December 31st, 2020. I think depending upon how the virus shapes out, it may be that is earlier or later. It all depends on how contagious it is and how much it can get under control. Which businesses are covered by this? Well, government employers and employers with fewer than 500 employees are covered by this. Now, this may impact businesses such to the point where it could cause them to be threatened to continue to be a going concern. So the Secretary of Labor has allowed them, is being given authority under this act to exempt businesses with less than 50 employees when it may cause the business to actually close it altogether. Employee eligibility. Who's eligible for this? Well, they've shortened the period of time. Now it applies to employees who have worked only for 30 calendar days. So that's a big change. And the leave is 12 weeks. Now the 12 weeks is not different from FMLA, but remember, FMLA, a qualified employee under FMLA, is allowed to take 12 weeks so long as the company in the meantime, it must preserve the position. It's a preservation of position act. It means that position must be returned to the employee when he or she comes back. It's unpaid under the current FMLA. And as of today, it's unpaid unless you're in a state that alters these laws. So currently in Florida, it's still unpaid FMLA. If this law comes into play, we will go into a discussion about paid versus unpaid in a second. But if it comes into play, I'll touch on it briefly. The first 14 days will be unpaid, and the remainder, which is about 10 weeks, will be paid. So let's talk about what is it expanding? Who does this apply to, this FMLA expansion, this benefit of a partial pay and a preservation of job as a result of the coronavirus? It applies to three main categories of employees. One, they're quarantined due to exposure to or symptoms of the coronavirus or coronavirus diagnosis. To care for an at-risk family member who must be quarantined due to exposure to or symptoms of or diagnosis of coronavirus. And three, and this is a more expansive category, care for a child of an employee if the child's school or place of care has been closed or the child care provider is unavailable due to coronavirus. So obviously, if due to a public emergency, if the school closes, which they have in Florida in significant parts of the state, that would qualify for this FMLA expansion. That's probably one of the areas where businesses will be most impacted, school closures. Okay, employee pay. How does that work? As discussed earlier, FMLA is usually unpaid leave. Under this scenario, this FMLA expansion, for those three reasons earlier related to the coronavirus, the first 14 days will still remain unpaid unless the employee elects to run accrued PTO concurrently. Now, the employer cannot require the employee to take accrued PTO during this time. So this leave will preempt and trump any accrued PTO. What do they get paid after the 14 days? Let's say the schools remain closed for 12 weeks and the first 14 days of unpaid leave runs out. Well, the expanded act says it's going to be at least 2/3 of the employee's usual pay. So they're giving you a bit of a break there. Now, this kind of segues into, and I'm jumping the gun a little bit, but it segues into what Mnuchin and Pelosi and the Senate are currently talking about is how do we help? There's a bit of a silver lining in this for employers. How do we help them pay this? And they're talking about tax credits, being able to pull money out of the IRS to be able to cover the expense of this expanded paid leave. And that is still in the preliminary stages, has not been solidified, but we're not surprised that once the Senate passes this bill, it'll include a manner in which there'll be financial relief to businesses that are subject to this to this additional paid leave.
And I'd just like
Go
to
ahead.
point
Yeah.
out for a second that, if you have for example, pregnant employee, right, who is wanting to take an FMLA leave, that is still an unpaid job protected leave. It doesn't suddenly, if this bill passes, it doesn't suddenly become a paid leave for a pregnant employee. The pay portion of it only applies for those reasons that Carlos just talked about before, related to coronavirus.
That's correct.
All the other reasons that an employee would otherwise qualify for FMLA leave, the employee still needs to meet the criteria of the 1,250 hours within the previous 12 months. They still need to meet the criteria for the eligible reasons for their own serious health condition or the health condition of a close relative, and then it remains an unpaid but job protected leave. It is only for these reasons related to coronavirus that it becomes the paid leave.
Right. Okay. The FMLA also expands certain definitions like parent now to include a parent-in-law of the employee, parent of a domestic partner of the employee, and a legal guardian or other person who served the employee's parents, also known as in loco parentis when the employee was a child. So a very, very employee-friendly expanded definition. So now let's get into the second part, which is very, very important, and that is emergency paid sick leave. The Emergency Paid Sick Leave Act is something that the government is trying to implement across all 50 states. Why is this important? Some states already have paid sick leave requirements. What the government is saying, states such as Florida that doesn't have a paid sick leave requirement in its laws must provide this paid sick leave. And how does it work? Well, again, it's effective 15 days after signing, and it sunsets on December 31st, 2020. Again, remains to be seen if that will be removed earlier. It covers employers and government employers and employers, private employers with fewer than 500 employees, just like the expanded FMLA. And unlike the expanded FMLA, the Required Paid Sick Leave Act covers all current employees, regardless of the days of service. If they start today and the act goes into effect tomorrow, they would be covered. Now, the important thing to talk about here is how does this work and how does it interplay with FMLA? And that's a very, very discussed and controversial argument right now at the Senate level and at the implementation level. Why? Well, this paid sick leave provides 2 weeks of pay, 80 hours for full-time employees, prorated for part-time employees. 80 hours, 2 weeks makes, if the FMLA, you're not required to pay for the first 2 weeks, well, this kind of fills in that gap for those first 2 weeks so that it becomes a 12-week paid period in effect if somebody has the coronavirus, for instance, or is qualified for paid sick leave and also qualified for FMLA. Having said that, there are a couple reasons as to why both of these acts are there. FMLA is a preservation of position act, and it's meant to preserve the job. There is a financial component solely for those 3 reasons that apply under the expanded FMLA. The paid sick leave has a little bit of a broader basis for when the paid sick leave applies for those 80 hours or pro rata if you're part-time. It's a little bit different than the FMLA. This applies, for instance, to quarantine due to coronavirus diagnosis. It's not a coincidence that it's 14 days. 14 days is the period of time that they say that the coronavirus can incubate and so forth. So it's 14-day period, and it's to quarantine. To seek diagnosis or preventative care for coronavirus symptoms, it's a little broader. To comply with a recommendation or order from a public health official, healthcare provider that the employee should work at home due to coronavirus symptoms or exposure. You got to meet certain risk factors. Then to care for an at-risk family member who must quarantine due to exposure to or symptoms of or diagnosis of coronavirus. And then the last requirement is very similar to the FMLA, to care for a child of an employee if the child's school or place of care has been closed or the child care provider is unavailable due to coronavirus. The rate of pay is a little different. If it's an employee's own health, for these 80 hours or prorated, depending if you're part-time, it's a little different. It's for the employee's own health, which is the first 3 reasons above, it's the regular rate of pay. If it's to care for a family member or child, it's 2/3 of the employee's regular rate of pay. So those are the two main issues. They kind of interplay with each other. It would not be surprising if the Senate bill delves a little bit into both of those and how they work together. But they do kind of play off of each other, even though some of the criteria is different as to who it applies to and how it's implemented from a pay standpoint. We're moving on to the expanded unemployment portion of this House bill.
Yeah, and before we even touch on the expanded unemployment, I will say we didn't include a slide on the tax credits because it is so in flux, but what has been reported, and Mnuchin has come out and said, and it's been reported in the Wall Street Journal, that they are looking at how this tax credit issue will work. Mnuchin has said specifically that he's not looking for employers to have to come out of pocket to pay the sick leave or the paid FMLA. Essentially, what he is envisioning is it is written into the bill that this will be administered by the Social Security Administration. And so they will use the money that the employer has already paid into the IRS to make these payments to the employees. And if the employer has not funded yet enough to make the payments to the employees, then the IRS will advance the money such that the employer is only paying into the IRS the amount that it would ordinarily have to pay. So it's not having to pay out an extra amount is what they're envisioning the program would look like. So we wanted to tell you that so it's not, all doom and gloom.
Right, agreed.
But it's still so uncertain that, as lawyers, we were a little bit wary of putting it in writing.
No, and I think Kelly capitalized on, he's talking about a very good point. I think the government is trying to capitalize on their tools and their ability to make this as painless as possible for employers to be able to muscle through this temporary crisis.
Right.
So the good news is, and the silver lining, as we said earlier, is there apparently is expected to be quite a bit of government assistance to get through these issues concerning expanded FMLA and paid sick leave.
Right. So another area that we're looking at the federal government to provide additional legislation is with respect to expanded unemployment. Now, this is a little bit interesting because federal law governs unemployment, but then leaves it up to the states as to how they each administer their own unemployment insurance program. So at this point, what has happened is the Department of Labor has come out, and I placed a link in the slides, so you'll get that at the end of the presentation when the presentation is circulated to you all. You can click on that yourselves. But they've circulated this guidance, the Department of Labor has circulated this guidance where they basically have told the states, look, you guys in a lot of cases are way more restrictive than we, the federal government, require you to be. And in light of COVID-19, you need to loosen up the reins a bit, and you're able to loosen up the reins a bit because federal law does not require you to have these restrictions in place for your employees to be granted benefits. So some states have already loosened the reins through emergency measures, whether it's the governor's emergency declarations that have taken place. Florida is not one of those states where emergency measures have taken place. Washington State is one of those places. Just as an example, I can give you their governor passed an emergency declaration. Not surprising, given that they have one of the country's hot spots. And what they've done in Washington State, just as an example of something that can happen in the unemployment setting, is that any quarantined worker who's not receiving wages can immediately receive unemployment compensation so long as he or she provides a return to work date from his or her employer. I've seen a couple others come through that appear to be proposals at this point. There might be one in Georgia. I'm not quite sure if it's been passed yet. It might be on its way to being passed, where instead of the employee actually applying, I believe it's the employer who's going directly to the state unemployment agency, and the employer can apply for the benefits on behalf of the employee. And so they are They are working on very similar criteria as Washington. The employer can claim on behalf of the employee in the state of Georgia a temporary time period where the employee is not able to work due to a quarantine or a temporary shutdown at the workplace. So there's a bunch of things in process. As Carlos mentioned earlier, Florida is not one of those places that we typically see proactive anything. We typically wait to see what the federal government says and then follow suit.
Yes, excellent. Let me ask a quick question. Can all of you hear us?
We got a note in the text box that it seems we're going in and out.
Okay, we got a bunch of yeses. Okay, good.
Yeah.
We will continue. Great. Okay, so pros and cons of exceeding legal requirements.
Okay, so pros and cons of exceeding legal requirements. We've got here legal requirements versus best practices, and flexibility is key. Flexibility, we need to be able to kind of pivot here a little bit, given that we've got the current state of legal affairs and the status quo being what it is. The current laws are in effect. Knowing that things are going to pass, and laws are going to change perhaps in the next couple hours, perhaps in the next couple days, perhaps again in the next couple weeks, and perhaps again in the next couple months. We are anticipating that that's going to happen. We have to be a little bit nimble. And where I say here, decisions made could have a long-lasting impact on individual employees and their families. What I mean by that is, take, for example, is there a legal requirement that you allow an employee to work from home? No, there is nothing in the law that says you have to, and outside the ADA context is a reasonable accommodation, like just forget about that for a second. But, in terms of this coronavirus, you have to let an employee work from home because of this coronavirus. Currently, no. Do we have to send our whole workforce to work from home? It might not be practical, right?
Right.
But, legally, do you have to do that? No. But if the alternative is you have to not pay them because they can't work, because they can't come in, what does that mean down the line? So we have to think, okay, what does the law say versus what might be a best practice? But then at the same time, you have to think, okay, well, if I do it for one, do I have to do it for all? And if I do it for one, but I can't do it for all, how do I make sure that it doesn't appear that I'm doing it for a certain group and giving special privileges to a certain group of people? Well, you're letting all the mothers go work from home and you're not letting any of the fathers work from home, for example.
Right.
So you have to make sure that, it's a balance, right? And this is where you can really work with your Regis HR manager to talk through these situations, because we recognize that right now employers are really trying to do the right thing, but they're also finding themselves in the same situation themselves, right? There's so much uncertainty, but they're all trying to do the right thing. And I think as long as we continue to try to do the right thing, that we can move together and get through this together. So this is all about being flexible and striking that right balance between what's practical, what's affordable, and what's required versus what you're able to do.
Absolutely. Okay, we're going to go now into specific HR concerns, part 3. I'm going to turn over to Kelly, but I want to talk about very big picture issues here. So here we're going to talk about workplace safety issues, travel policies, work from home. These are called the telecommuting policies, FLSA implications, furloughs, WARN implications, layoffs, healthcare privacy concerns, workers' comp and unemployment compensation. From a big picture standpoint, for the most part, all of the existing laws still apply. You are to continue to manage your business and conduct your business abiding by all of the current laws. We touched upon this earlier. However, there are measures that companies are taking from a business standpoint that they want to be careful about and do it in a fashion that is not violative of certain laws. For instance, travel policies. We're going to get into a very good question and answer session at the end that goes through many of the questions that have been posed to Regis and many of the questions that have been posed to us, and it'll hopefully answer most of your questions. But some of the obvious ones are, I've had employees travel to different parts of the world. Can I institute a travel policy where before they get back to work, they've got to go through specific procedures and protocols? The answer is yes, but you need to do it in a manner that is non-discriminatory, doesn't violate their rights, but there is an ability to deal with travel-related policies when they return to work. There are these telecommuting policies, remote from home policies, which you're, like Kelly said earlier, you want to apply them in a manner that doesn't create a disparate impact or treatment, but you can also apply them in a manner that allows you to muscle through this virus crisis. Like we said earlier, you may want to have 2 weeks on, 2 weeks off. Certain groups of employees go home, others stay, or certain, do it in a manner that you're applying it in a very non-discriminatory, legitimate fashion that makes sense and serves the best interests of the longevity of the business. FLSA implications are all across the board here. Don't do something that might violate your FLSA laws. If somebody works for you, you have to pay them. Can you say, come work for me, but I'm not going to pay you for 3 months, or I may not even pay you? The answer is no. The FLSA gives guidance that if somebody works for you, you need to pay them promptly, which is usually in Florida a week to 2 weeks. Some try and push it to a month, which is discouraged, but try and keep it within your by your week to every 2 weeks if possible. So at the same time, the FLSA and the existing laws do allow businesses to take certain measures that, for instance, reduced pay and to change the structure of the business in order to survive as a legitimate going concern. Those are allowed. The trick there will be, or the challenge there will be, how do you do it in a manner that doesn't violate applicable laws, such as in a discriminatory, non-disparate fashion, or in a manner that doesn't violate minimum wage, doesn't violate exempt versus non-exempt status. All of those kind of questions are issues that if you're planning on doing, Regis can help you through, and if they need to elevate it to legal, they will. But from a big picture standpoint, continue to be governed by the business laws. You are allowed to take decisions from a legitimate business interest standpoint, but don't forget that there are several laws out there that do apply if you plan on restructuring, if you plan on getting types of severance agreements, or if you're a big enough company, you're planning on doing a mass layoff, a furlough, and how that applies from a warrant standpoint. So I know we've thrown a lot out. I'll turn it over to Kelly, but the big picture is continue to abide by existing laws, and without the paid sick leave in place, now this act in place, most of what you're going to be governed with as of today are what you're used to governing historically.
Yeah, thanks, Carlos. So I want to kind of just go through this quickly, because as you'll see in the next section, which is the Q&A, where we'll talk about specific questions and answers, it's going to kind of follow these specific topics. And Carlos did a pretty good job talking about what each of these, what the hot button issues are within each of these bullet points. In addition to what he did mention, though, there's two I'll say at this point, kind of big call outs that I want to just draw your attention to, because we don't really address them in as much detail in the Q&As. The first one that I want to talk about is the WARN Act, just because I want it to be clear for all of you on the phone what it is and what it means to you. The WARN Act, the purpose of the WARN Act is to prepare workers and families for a prospective loss of employment. And what it requires is that employers provide 60 calendar days advance written notice of an employment loss, or a loss of employment. Now, who has to do that? It's employers with 100 or more employees. And how do they count that 100 or more employees? It does not include employees who work less than 20 hours a week, and it does not include those who have worked less than 6 months within the last 12-month period. What does it apply to? It applies to the closing of a facility or an operating unit for more than 6 months. So if you're looking for a shutdown in a less than 6 month period, WARN probably doesn't apply. If you're looking at 50 or more people being laid off during a 30-day period at a single location, we may have WARN implications. And then for mass layoffs, now this is layoffs lasting at least 6 months, 500 or more workers, or at least 33% of the workforce when the layoff affects between 50 and 499 employees. So, whether it applies or not, the guidance that we've been giving our clients is going back to that original bullet point. Communication is key. The more you can communicate with your employees, we're all in the same boat here. The more and better you can communicate with your employees, the more empathetic you can be with your employees, the better it will be in the long run for everyone. The DOL does have guidance on how and whether the WARN Act applies in natural disasters. It does still apply in natural disasters. It's questionable whether a viral pandemic would be considered analogous to a natural disaster. But in the guidance that the DOL does provide, it says you still have to provide the notice. So you might not be able to provide the notice before the earthquake destroys the factory, but you have to provide it regardless. So what we've been advising clients, think in the restaurant industry, for example, is if you're going to have to shut down your restaurant, still provide the notice. It might even be after you've had to shut down the restaurant, but say, look, provide, we've had to close the restaurant temporarily. We're not quite sure when we're going to open. This is the name, this is the address and contact information we have on file for you. You're going to be first in line for rehire when we do reopen again. If this information is not up to date, please provide us with up to date information. If anything changes, please provide us with, up to date information. Here's where you can get in touch with us, and that sort of information. Even if it doesn't apply, you've showed good faith and you've showed an attempt to comply with any sort of notice requirement that may ultimately get you out of, not a get out of jail free card, but show that you've attempted this good faith effort to comply with the law. So that's WARN. The other one that I wanted to call out before we get into the Q&A is this healthcare and privacy concern. So one of the things that we're going to be going through with workplace safety issues, there's a lot of Q&As with employers asking questions about employees showing symptoms of COVID-19 and what to do and how to act and how do we communicate within the workplace. Nothing. If you learn nothing else from this webinar, nothing about HIPAA has changed. You cannot disclose the name of an employee who is suspected of having COVID-19 or has tested positive for COVID-19. So please, if you get nothing else out of this, do not disclose the name of a potentially or confirmed case of COVID-19. So that has not changed. I think we can move on to
Question and answer.
the Q&As.
A lot of this we've already touched on, but these are our specific questions that have been raised by Regis clients and that we've decided makes sense to at least incorporate as part of this presentation. And then at the end of this, if we have time, we may be able to address a few more, but go ahead.
Yeah, absolutely. And we tried really hard where we could to actually give you answers and not the typical lawyer, it depends answer. So to the extent where we had to give you a lawyer, it depends answer, it really is because it depends. And I hope you'll appreciate that. So the first question, and like I said, this is where we get into this workplace safety kind of category. And there's a whole bunch here. There's probably like 5 or 6 in a row that are kind of all very similar. What do we do if an employee comes to work with COVID-19 symptoms? You can send them home. You can send them home. You can ask them to seek medical attention. You can ask them to get tested. Very important here is training of managers, having them not overreact, maintaining a sense of calm. We do not want, again, we want to make sure that we maintain the privacy rights of the employee. Here's a big one though, and you'll see it here in this answer. There may come a time where maybe not this employee, but another employee, any of the employees in your workforce may actually end up with a positive COVID-19 diagnosis. So anytime you're dealing with an employee who has symptoms and comes to you with symptoms, or you go to them because you've noticed they have symptoms, you should proactively obtain from them a list of all of the other employees, clients, visitors, anybody that they have come in contact with for the last 14 days, which is the incubation period for the illness. The reason for that is because if that employee eventually tests positive for the illness, either you as an employer will have to inform those people on the list, or the CDC or the state health agency will come to you looking for the list for them to inform the other people on the list of the positive diagnosis and the need for those folks to go into isolation during the pendency of the incubation period. So it's vitally important that we get that information as soon as is possible, which would be at the time the employee is showing symptoms. Can I check the temperature? We're getting this one a lot. Can I check the temperature of each employee daily as they come into and leave work? And I think most people understand that typically the answer to this is no, because of the ADA and it's a medical exam, or viewed as a medical exam. There is that exception in terms of it being a direct threat to the employee or the community. At this point, the CDC has not come out to say that it's a direct threat within a widespread community. So at this point, you get the lawyer, it depends answer. And I promise it's really only for this one and maybe one or two other questions in this long list of questions. So we recommend against this one. Also from a practical perspective, many people who are thought to be spreading this virus are asymptomatic. So taking temperatures wouldn't really help anyway.
Okay.
Oops, sorry.
Oh, sorry.
Oh. There we go. Okay, what do we do if an employee does test positive? What do we do if an employee wants to return to work after having symptoms? Again, we kind of talked about it. Send them home to prevent the further spread. If they test positive, get the list of employees. Be mindful of privacy laws. Don't disclose who's tested positive. The talking points there are to the other employees, you have been in contact with somebody who, or you may have been in contact with somebody who has tested positive for this illness. You need to seek medical advice from your physician. With respect to an employee who wants to return to work after having the symptoms, maybe not necessarily testing positive, but having symptoms, you can certainly request that the employee obtain a note from his or her physician before returning to work.
Yeah, this is an important one to talk about. And everybody's, well, why can't we just identify the employee and tell everybody that that person has COVID-19? Well, there are several issues here. One is you need to be careful about HIPAA. HIPAA precludes you as an employer from divulging certain information that is private and protected. And also there are other issues like ADA concerns and so forth, where you have to be mindful that the ADA still applies. And by being so forthcoming about an employee's condition, there might be a violation of that employee's rights. However, Kelly touched on it very well. There are ways in which you will act in a scenario where you do have an employee that has COVID-19. For instance, CDC will likely even inform you. And when the CDC gets involved, they will ask you potentially, and it's good to keep track of who that person interacted with and so forth. But if you as a business feel compelled to have a discussion with your employees about the situation, there's a way of doing it without disclosing the name of the employee and the situation. Most people will get the big picture and they'll get it and they'll see what's going on. But you don't want to violate privacy laws or ADA laws. And some of this may naturally come to a head as a result of the actions of the CDC if they come into your workplace and discuss with you and so forth. So the important thing is here is that if somebody is infected by the COVID-19, then it's important to disclose to your employees the importance of being tested. That pretty much speaks volumes to the employee. They get it, they understand it, and they move on. Much of this, of course, may also be when you're in a telecommuting situation where you may have employees at home anyways. So some of this stuff may be behind the scenes and they're not at the workplace. But the importance of following the CDC guidelines, which are very well drafted and out there for assistance, will help you get through this. But the important thing is right now, the overwhelming recommendation is not to be singling out individuals, but giving enough information to the employee that they can go and take care of themselves.
Yep, absolutely. This one came in from a Regis client as well that I thought was really interesting. What precautions should we take for employees who need to take public transportation? Something that I didn't even think of, because with how focused everybody is on disinfecting, I thought public transportation may in fact be more disinfected than my own personal vehicle, to be honest. But from an employer perspective, remind employees of basic hygiene protocols. Employers should make sure that they have hand washing stations available with soap and water, and or hand sanitizer with a minimum, CDC recommended 60% alcohol available to the employees. If there are additional concerns about, overcrowded and the inability for social distancing with respect to public transportation, you can evaluate whether remote work or other opportunities to limit interactions exist. With respect to interactions within the workplace itself, like once the employees are in the workplace, you also want to be looking at limiting interactions there as well. So perhaps looking at having conversations over the phone or email as opposed to in person in each other's offices, or having video conferencing meetings as opposed to around a conference table, those sorts of things.
Great. Okay, move on to the next question. What do we do if an employee is afraid to come into work for fear of contracting COVID-19?
So this is interesting. There's nothing right now that appears to rise to what would allow an employee to legally stay home, legally refuse to work. But this is definitely one where you are going to want to talk through the circumstances of the employee's concern with your Regis HR manager, because this is a very fact-specific inquiry, and they can talk you through what the concerns actually are and what potential solutions there are to those concerns.
And this is a very, very good point. Understand, right now in Florida, the paid sick leave has not been implemented, and where these situations are going to come up now without a law in place that forces businesses to act in a certain manner, you're going to defer to the Florida, if you're in Florida, for instance, the Florida statutes and your company policies. So right now there's no required paid sick leave or PTO. So in short, you're going to follow your company's practices. So if you have an existing program in place, continue to follow that practice for purposes of specific issues that arise on a day-to-day basis. But it may change in the next day or two. We do think, though, that this required time off is going to be more geared towards the coronavirus specific criteria that we discussed earlier when we talked about the House bill. But as we stated at the beginning of this conversation, status quo, laws and company policies are still in effect, and companies and employees should be expected to abide by them. The fact that somebody is fearful doesn't mean that you have to change your company policies.
Right.
Take a look at the CDC guidelines. Take a look at the criteria under the expanded FMLA and paid sick leave we just went through, and that will eventually go into law as amended. And that's how you should govern yourself when it comes to these issues.
Yep. All right, the next two questions deal with travel, as we touched on with the bulleted topics before leading into Q&A. So the questions are, can I prevent employees from going into the workplace following their return from domestic or overseas travel? Yes, you can. Look at your current policies. If it doesn't address it, probably does not address it. You certainly can amend them or rewrite them such that it does address them. I have done standalone policies. I have amended workplace safety policies to allow for travel policies to address this particular issue in this coronavirus time. And they are very easy to do, simple to understand. and clients and employees seem to understand the intent behind them, which is not punitive, but rather geared toward workplace safety. Next, can I restrict employees from traveling on their personal time? No, you can't tell your employees you can't travel on your personal time, but just like I mentioned, you can restrict whether they can return to the office based on when they return, based on where they traveled and based on what your policy says. So
Okay, great.
that is travel.
What do we do if school is closed but workplace is open?
Okay, so we are all experiencing that right now, myself included. It is likely to be addressed in the proposed expansion to FMLA and emergency paid sick leave, but this is an area where it might make sense for employers to be flexible while also making sure they're treating employers consistently and not opening themselves up to discrimination claims. So looking at remote or telework, alternating schedules, that's 50% of the employees coming in for 2 weeks and then 50% going in the next 2 weeks. Any other alternatives should be explored. And by alternatives, some of the things that you may want to be looking at, I'm sorry, everything is running together. So if I mention this and I'm being duplicative, I apologize. But things like if your employees need certifications, if you're a restaurant and you have employees who need food handling certifications, have them sit at home and do their computer work for their food handling certification. If you are a business that has been thinking about outsourcing, digitizing some of your records, buy a scanner and have somebody sit there with boxes of records, feeding them through a scanner, and you know, whatever alternatives you can come up with to keep people in the workforce doing things that you ordinarily would have paid somebody to do, even if it's not necessarily what you hire the person to do, is things that should be explored.
Yeah, and important to understand that the telecommuting and remote workstations that you're doing really apply when you can do that, of course. And there are certain circumstances where you can't actually do these creative options and so forth. So and we'll get into this a little bit further down, but some of the questions that we've seen come up is, well, wait a minute, everybody's talking about a telecommuting policy, but my business doesn't cater to that. Do I need to continue to employ these individuals, or what can I do? Can I change their salaries? Can I lower their pay? The answer to that question is current laws apply, and the answer is yes. But you can make changes to your existing business operations, but you have to do it in a legitimate business manner where it doesn't create a disparate impact or treatment or create a discrimination claim, and where it abides by FLSA, minimum wage, and the laws that are currently in effect. So what's going on with the coronavirus? Let's not confuse that there's a national crisis, a worldwide crisis going on right now, with the fact that a business still has rights to operate and function in its ordinary fashion. What the government is doing as a result of all of these proposed stimulus packages is they're trying to help the employer to keep these employees on your side. The government is not mandating that there has to be an alteration of your business, and you must have them work at home when they can do nothing but sit there and watch the internet. No, what the government is doing is do everything you can to survive. We're going to try and help with stimulus, small business loans. We're going to try and deal with all of these issues and hopefully help you get through this period of time. But the laws still apply. Currently, even if this crisis had not taken place, businesses can restructure. They may lower compensation. They have to look at their employment agreements, see if their employment agreements actually prohibit you from lowering their employment. You need to renegotiate. If there is any type of significant act where you're going to furlough or you're going to do a group termination, that does raise some legal issues to see whether or not you qualify under the WARN Act and if there's notices and so forth, or if it's considered a group termination where you're offering severance. What are the disclosure requirements? Those still apply even if this virus had never even occurred. In those situations where you find yourself in a situation where you will not continue to be able to, you need to restructure whatever impact it has on the employee, of course, speak to Regis, and of course, take a look at what the government is doing in the next 24, 48 hours in the next several days, because it might impact your industry and it might allow you to do some of these alterations that we're talking about in a manner that might allow you to muscle through this epidemic,
Yep.
this pandemic.
Okay. Kind of building on schools closed but workplaces open, can we set up a daycare or a kid-friendly area in our office for our staff that does not have alternative childcare due to COVID-19 related shutdowns? The answer here is a pretty easy no. Daycares need to be licensed, and while we understand that this is well-intentioned, one purpose of closing schools is to encourage the social distancing, so that completely defeats the purpose to have all these children together in one place. There may also be insurance issues beyond the licensing issues. You know, we look at the alternatives to working in the office as something that can be explored, but it might ultimately be made moot by the proposed FMLA expansion. What do we do if an employee requests leave to care for a family member diagnosed with COVID-19? Okay, definitely consult with your Regis HR representative, because this is one where it may be covered current state FMLA. It may not be, depending on the severity of the COVID-19 infection. For some people, it presents as a cold. That would probably not be covered by FMLA. For some people, it is a major life-threatening infection. That perhaps would be covered by FMLA. So it's going to be a fact-specific inquiry. You'll need to consult with your Regis HR manager to help walk you through that. Again, if and when this bill is passed, then certainly if it passes as written, it would be covered by this expansion.
Yeah, I actually agree with Kelly. I think what's going to happen with the passing of this bill, the goal is, and I think one of the reasons that the House bill didn't get voted on Monday was there were a lot of open questions and details that were missing. They've used this week to kind of flesh out a lot of these. So we're hoping that they provide a little bit more detail and guidance when it comes to discussing exactly how you will go about being qualified for expanded FMLA and paid sick leave. And we suspect that there should be some guidance in the coming days. That's at least what a lot of the talk is out there and the goals are. Clearly implementing something like this, you know, takes quite a bit of detail to be able to guide employers. Okay, do I need to continue to pay employees who are not working?
I feel like a bit like a broken record when we say that the laws have not changed. The FLSA has not changed. So for the most part, the answer is no. If your employee is not working, you don't need to pay them. But there are circumstances in which you may be required to keep paying somebody. Examples would include salaried exempt employees who have worked during a partial week. If you have contractual obligations pursuant to an employment agreement, if you have a unionized workforce, then there's a collective bargaining agreement in place that would require you to pay. Before making a decision not to pay, you would consult with your Regis HR representative to determine whether additional legal support is necessary. This is one of those legal versus best practices questions as well, because one of the questions we keep getting is, I may want to, and we may get to this a little bit further down, and I think we might have seen some questions come in about it as well. I may want to furlough some people, or I may want to do some temporary layoffs. Can I lay people off or furlough some people for 6 weeks, but pay them, you know, can we pay them $100 a week or $50 a day, or, you know, can I do that? Yeah, you can. You don't have to worry about minimum wage if they're not actually working, right? Because minimum wage is you have to pay them the minimum wage for the hours that they worked. If they're not actually working, then the minimum wage doesn't apply. So what you're paying them is not related to the FLSA.
And the other thing that's important here is if they're not working and you're keeping them as an employee and they've earned PTO, or if they're being terminated and they have earned PTO under your existing company policy, make sure you honor those obligations. Of course, they may decide to take some time off. Remember, what still applies still applies.
Yep.
What do we do if there's a shelter-in-place order or my place of business is otherwise required to shut down due to a municipal or geographical quarantine?
Okay, so this is kind of a two-parter. So either my employees can't come in because they're not permitted to leave, or my place of business has to shut down because I'm not allowed to operate. So what do I do? Again, we keep harping on this remote work, understanding that it's not practicable for all industries. So what do? You can shut down operations. If you cannot operate whatever industry you're in without being in your particular location, you can shut down. That's okay. Yeah. One of the things that we suggest you look at in advance of making that decision is, what do your PTO policies say, and can you afford to have every single one of your employees use every single bit of accrued PTO they have right now? If you can't afford it and it's going to bankrupt you and send you out of business, you may want to revise your policy right now to say, in light of the COVID-19, pandemic, we are temporarily putting in place the following PTO policy. We are limiting the amount of accrued PTO our employees can use for this period of time, and outline what you want it to be, so that you're being fair, but at the same time you're not bankrupting yourself.
Okay. Moving on to that. What options do I have for pay cuts, temporary closures, furloughs? We're in the final two questions, and layoffs.
So if you have to, we've kind of just covered this, if you have to cease your business operations temporarily or permanently, you've got options. Forget COVID, you can always shut down your business operations. I mean, there are executive orders and emergency measures that are being put in place to try to not prevent you from shutting down, but to try to help you from having to shut down, I guess is the best way to kind of put it. Because it's obviously in the best interest of the country's economy to keep everyone employed. So these issues are so in flux right now that that we would strongly suggest talking to your Regis HR rep again to make sure that all of your options. There are changes being made, executive orders being released by the day, if not multiple, both at the state level and federal level. New laws, rules, regulations coming out that you definitely want to make well-informed decisions. But there are options. There are options along a huge continuum. So you want to make sure you know what they are before you make your decision.
Yeah, and the existing laws, as you say, still apply. For instance, WARN, you need to ask yourself, do you as a business, are you large enough to fall within WARN? Because if you do fall within WARN, there are specific notice requirements. There also is language in there concerning natural disasters. Questions are being floated around as to whether the pandemic virus is a natural disaster for exception purposes. Those are all legal issues that are coming to a head as a result of this pandemic. And I think we're going to be hearing more about that in the coming days, and possibly as a result of what the Senate is doing at the presidential level and the Senate level. And we'll see where these internal regs and details come into play. You're dealing something that's not a typical natural disaster, such as a hurricane or something of that nature.
Right.
This is obviously
there's still some ability to plan here. There's still some ability to plan, just like with a hurricane. There's still some ability to plan.
Right.
It's almost like a different from like an earthquake or a tsunami, where there's no ability to plan, right? It's completely out of the blue.
Right.
So, we have to be careful what analogies we're drawing and what history we have to show us what direction to take, but we have options.
But it's important to understand that the WARN Act is very specific, and you're going to go online, you're going to find a lot of resources about it. And even amongst those resources, the problem with the WARN Act and specific issues that involve larger companies and shutdowns and so forth and notice requirements is that unfortunately, the government didn't anticipate a lot of these scenarios. So there is a debate as to whether certain provisions are invoked in a situation such as a pandemic virus. Those are issues that you can take to HR and elevate to legal as appropriate.
Yep.
Of course, working closely with Regis will elevate you to legal as needed and from your perspective. But those are issues that are still in play, but you will likely see some more guidance on some of these issues as to what other businesses are doing in light of some of the gaps in the current laws. So let's wrap it up with one of the final questions. When should employees start applying for unemployment?
So I say yesterday. and only sort of kind of joking. So here's the deal with unemployment, particularly in the state of Florida. As we mentioned earlier in the presentation, the federal laws that are looking to be passed are asking the states to expand their administration of the state unemployment laws. Florida will not do anything on its own, or will likely not do anything on its own. So we are waiting for any sort of federal regulation before anything happens in Florida. Florida is one of the most difficult states for employees to obtain unemployment, and the benefit itself is fairly low comparative to other states. We don't know what or how that process will be modified. So what we are recommending is that because it is very burdensome for employees to be eligible, which right now, if an employee has been terminated because of COVID-19, like as in they have lost their job, they are not receiving benefits, then they would be eligible, okay? But if you're keeping them on the payroll, or you're keeping them as a full-time employee, even though they're not getting paid, just so they can continue to receive benefits, those are things that'll make them ineligible to receive unemployment. So while you're doing good by them from a medical or healthcare benefit perspective, they won't necessarily be eligible for unemployment. There's other requirements that they need to show, one of which is very burdensome and very difficult to overcome in the age of COVID-19, which is they have to show that they are attempting to obtain other employment by proving that they have applied to 5 jobs per week. Well, in the age of social distancing, I don't know who can show that they are applying to 5 jobs per week. So it's going to be very difficult for employees to be eligible, to be deemed eligible under the current status of Florida's unemployment. However, when things do get revised, we don't know how it's going to be administered. But if it's going to be on a first come, first serve, if employees are already in the system, that will give them a leg up. So we are recommending that if employees ask, when should I apply the second they see their change in circumstances, whether that is a reduction in pay, whether that is a temporary layoff, whether that is a loss of job. Any of those 3, get their paperwork together and fill out their application, submit it. It's all through the online portal, and then they'll get a rejection. I mean, you can prep them for getting a rejection, but they can at least get their number in line, so to speak.
And in short, that takes us through the crux of these issues. In short, what to be watchful for. I think on a lot of these levels, the state works very closely with the federal government is going to be working very closely with the respective states. We do feel that we're going to be hearing in the coming days some very creative public-private type scenarios, partnerships that you'll see where there may be some voluntary programs that'll come up. There's no guarantee that'll happen, but that may be, I think people are starting to really think outside the box, because this is the first time, I guess, in a long time that this country has, if ever, dealt with something of this nature. So you're gonna be seeing some of these. How does that impact your business? So there is a silver lining here, in that people are constantly trying to come up with creative options, and a lot of what's in the House bill may very well be supplemented with some creative options. But the hope is that the government obviously does something that allows businesses to continue, and the businesses are able to thrive. And we wish you all the very, very, very best during these trying times. Carlos, would you like us to address some of these questions in the chat room?
Yeah, please. Absolutely, if you don't mind.
Okay, great. So we're going to scroll all the way to the top. All righty. So the government has issued an executive order for restaurants to limit seating and not shut our doors, which conflicts with our local mayor. Who should we listen to? Very, very good question. I actually we have not, I think this is probably coming out, in a fluid scenario. I would not be surprised, number one, if the mayor and the governor come to a consensus. This is obviously not something that there's no time for the government, for the federal, the state, and the local politicians to be claiming territory. But this will default into an area of law that's called preemption and preemptive law. So a lot of this is it's not an answer without researching. It's a difficult answer. Why? Certain areas of preemptive law may be applied differently. So it would be a case by case scenario. The typical fallback is that state trumps over local, federal trumps over state and local. Having said that, there are certain issues and certain ordinances and rights that are reserved at the local level. So it would have to be studied. But I would be very surprised if the governor and the mayor do not come up with a very quick solution for any conflict on any type of policy involving local businesses. I think the goal is that you'll probably be hearing something sooner than later. But this is an area of preemption that obviously is very, very specific.
Yeah, I think the reason for the conflict here is that it was spring break time in Miami Beach, and nobody, and I think where that question's coming from is somebody in the restaurant industry. Obviously, nobody was adhering to the social distancing measures that were requested that we participate in. So the mayors of Miami and Miami Beach both said, shut your doors,
Yeah.
right? So because they were concerned about the spring breakers who are not necessarily residents of Miami and Miami Beach, who are going to get the rest of the residents sick. So they were looking out for their residents versus,
And if they don't come to an agreement, which we expect they do, you will likely see arguments on both sides about preemptive law, preemption, and who has the authority over this specific area, including these health-related concerns. So it may be that if there is no solution, it would not surprise me if the mayor and the state can't come to an agreement, that they'll be falling back on arguments, especially involving that it's within their control and their realm because it deals with local health issues. I'm not saying that will carry the day, but I would not be surprised if they agree, and if they don't agree, both sides will be arguing whether or not they govern under preemption laws. All right, as of today, are there any government stimulus for small businesses, real estate landlords, and how to apply? Very, very good question. I think the biggest area that we have heard about helping small businesses has come from the SBA, from small business loans that the government has authorized, and that Mnuchin, the Secretary Mnuchin, has authorized be implemented immediately. The SBA has a very good website that will take you through the mechanics of how those loans will apply. Our understanding is that they are currently working with state governments on an expedited basis to get these loans in place. They're supposed to be low interest loans for respective periods of times, but you're going to likely be hearing more guidance. But the federal government should be working in tandem with small business, with the state at the state level, and small businesses, and may even have partnerships at the local level. The reality is that these issues are in flux. I think that the government now is doing a bit more than they were talking about a week or two ago. The focus before was on SBA loans and stimulus. Now you've been hearing the government talk about putting cash in the hands of employees directly. You're hearing the government attempt, looking into helping out specific industries directly, whether they're restaurants, airlines, and so forth. So I think there may be additional stimulus measures, but the main one that's been thrown out there, pretty much, as a cornerstone, has been small business loans and how to execute those. We recommend you go to the website. SBA has a very good coronavirus page on this, and it'll take you through specific criteria to qualify for that. But don't be surprised if you start seeing a bunch of other ideas on how to help small businesses get through this. One other area is Steve Mnuchin and the tax credit concerning the paid sick leave and and how the paid sick leave will work with the tax credits. So that's another area that the government is trying to help small businesses and so forth too. That affects, medium to large size and small businesses, but you'll be hearing more.
And then in the last week or so, I'm not sure to the person who posed that question, if you're in the state of Florida, I also saw Governor DeSantis here in Florida authorize the release of funds for the state Small Business Association to fund and release funds for that loan program as well.
And this is so recent that they're scrambling. We're sure they're scrambling, and there'll be more guidance. And then there'll be much more guidance coming out in the coming days, is our expectation and our hope, as is the hope that from a small business standpoint, that we hear more from the Senate and see where things are going there. Okay, let's move on to the next question. I have a call center. I cannot accommodate them to be 6 feet apart, and they cannot work from home. They are worried. How to respond to their concerns about the virus transmission? Well, as you know, currently there is guidance out there being issued on how to interact with this social distancing and so forth. There is guidance about social gatherings of not more than 10. Those are not laws and in place forcing companies to shut down if they can't operate under this scenario. Having said that, the goal is that you attempt to accommodate them as best they can to be able to continue to work. But technically, there is no mandate upon the company that in your employment office, you must have them 6 feet apart. It's the recommended guideline and good practice.
Right. So to that extent, we recommend making sure that you have as much hand sanitizer as you can possibly get your hands on, the Clorox wipes. You may want to consult, I don't know whether you own your space or if you lease it, or what contact you have with building management in terms of increasing the schedule of cleanings and disinfectings. You may want to provide additional cleaning supplies for the employees to clean their headsets, that I'm assuming they use headsets as opposed to actual phones if it's a call center, disinfecting the headsets. If it gets to the point where the distancing becomes mandatory, you may need to look at having only half the people work at any given time, where you're able to separate them and have half the people work, but separated, and then swap.
Yeah, I think that's a good point. The telecommuting policies will become very handy in these scenarios, and
they wouldn't be able to work from home, but half of them would work at any given time, and then the other half would come in the office.
The telecommunicating parties may come in handy, especially if a lot of people are being very creative. I know there are a lot of voice over IP phones, and there's a lot of technology that is allowing businesses to operate remotely. So if you're one of those businesses and you're stuck in a situation where you can't abide by these guidelines for social distancing, sometimes you're able to set them up from an IT perspective at a remote location, a different location, or even from home to satisfy some of these guidelines. But there is going to come a point with some businesses as to practically what they can and can't do. And that's going to be, there's a brave new world. That's going to be very, very telling on claims that arise. So, if people come back and say that, well, a business didn't follow the company guidelines, the defense there is a legitimate business defense, which is we can't operate. However, if you could take measures and you can do things such as a remote location that's not a significant burden, the recommendation is to be able to comply with these guidelines as best you can in light of the circumstances and in light of existing technology. I think those are things that are important. If you can do it, definite recommendation is to do it. Remember, they're at will. So if they're at will rather, and they don't want to work at the business, they're not obligated to stay at the business. But I think attempting to do it in a manner that allows you to continue as a going concern is the recommended course of action. And these creative telecommunicating remote workstations are being used quite a bit across the country. All right, next question. How creative can employers get in terms of restaurant employees? Can they be repurposed to do other job functions in order to continue paying them and save their job? That is an excellent question, and a question that affects a lot of people. The answer is you can. Currently, all of the existing laws still apply. Most everything, other than the few things that are coming out at the state level, apply, and you can repurpose them, but the manner in which you repurpose them is important. For instance, let's say they serve tables. You may need to get them into drive-through, or you may need to get them into takeout and so forth. Well, some of those have ramifications. Can you restructure their position? You can. What you want to do is in a uniform manner that avoids disparate treatment and disparate impact. If they're going to be driving now, you want to make sure you have the proper insurances out there. Make sure that if you have the proper automobile-related insurance because they're driving across the city. So the function will dictate how you need to adapt from an employment standpoint. By repurposing, the key there is that it not be looked upon by a protected class as an adverse action. That's why you want to do that as best you can in a uniform, non-discriminatory, legitimate manner. But it can be done. Take a look at any employment contracts, of course, and I think communication is important here and how you communicate with employees, but it should be done in a uniform, non-discriminatory manner, and make sure that you're, from a business standpoint, you've got the proper insurance and infrastructure to be able to transition to that. In fact, the government is recommending that restaurants, they want to keep those jobs, if they're able to do drive-through, if they're able to provide a takeout and so forth, they're encouraging that, even though they've also issued the guidelines of no more than 10 in any social gathering.
So, you know, where it says how creative can we get, you know, think outside the box. It's not just, okay, we've got servers, can they be delivery drivers? You know, you can have them redesign your menu. You can have them redevelop your website, develop a social media presence. I mean, things that, you know, they may not be thinking of in terms of, you know, or you may not be thinking of in terms of a restaurant employee. But if you've got a college student who's a marketing major and they work for you as a server, you know, have them work on your Instagram page. You know, anything that they're doing that they can be paid for, you can get very creative there.
Yeah. All right, next question. Can you adjust work hours for everyone now to prevent from letting go any one individual for not having future funds in your business? Now, it goes back to a similar concept we've talked about, and that is existing laws still apply. You are allowed to adjust work hours. However, take a look at any employment agreements. Make sure you're not violative of any employment agreements that are in place. If you're going to be adjusting work hours, make sure that you continue to abide by the minimum wage and FLSA overtime, FLSA requirements, etc. You still have to abide by all of that. The important thing here is also that you're applying it in a uniform manner to avoid a disparate treatment. Why is it you want to avoid an argument that why is the adjustment being applied only to women and not men, or those that are over 40 and over and not under 40? You want to avoid those Title VII related disparate treatment impact type claims. You're allowed to restructure under the existing laws. Just do it in a legitimate business manner. Okay. Can you adjust? Okay, that's the same question. All righty. Our business can only support telework, telemedicine with the higher level personnel. All line staff cannot do telehealth per insurance carriers. What then? That's a very, very good question. One of the things that if there's a requirement in your industry when you're dealing with insurance carriers, probably a good idea to contact the insurance carriers to see if they have any guidance out there. When it comes to the manner in which you conduct yourself as a business, there's nothing out there that's providing guidance that if you can't work remotely, you can't operate. You're gonna have to make a decision from a business standpoint is, can you set up a structure that will allow you to survive these trying times and comply with the requirements in your industry? But if they can't do it from a practical standpoint, I think going back to technology, going back to dealing with it with your respective industry trade organizations, how are they dealing with those situations is very, very, very helpful. In the end, if it becomes impractical and you can't, it's impossible in light of everything that's going on, or there's a group of employees that are affected by the coronavirus, then of course there is no bar in termination. The key there is follow the appropriate downsizing mechanisms based on the size of your company and the applicable requirements. The current laws do allow downsizing. You just got to do it correctly under the laws. Also, check the government resources that are coming down the pipe. They may impact your scenario depending on what is and is not passed. But definitely the best recommendation we can give is try your best to survive as best you can. See what government resources are out there. Check your trade organization to see what other people are doing to survive. Follow the laws. If you do take specific measures, consult with your IT personnel. See if there's anything with this creative and innovative technology that can be done to limit the economic burden on you for doing remote or telecommuting. And I think communication with those in your industry will probably be very, very helpful. If it, okay, I'll let you get that one.
If an exempt employee starts the work week but only works one day, do you have to pay regular salary for the entire week? Generally, yes, but there may be reasons why not no. So I would say, because it's fact specific, consult with your Regis HR representative.
Yep.
If they need additional legal support, they can get us or their attorney involved.
One other issue that's coming up quite a bit is a lot of exempt employees have employment agreements. Mm-hmm. So there's nothing stopping companies now from renegotiating or amending those employment agreements. Of course, those employment agreements may very well have that it can only be amended by mutual agreement. They may or may not, but they usually do. They usually don't have a unilateral right unless specific circumstances. But it's important to talk to your employees, review your agreements with legal counsel, and see if there's anything that can be structured for a lot of these employees, especially exempt ones, that are not going to be working or getting the level of productivity that you are expecting and so forth. But current FLSA guidelines on pay still do apply for both non-exempt and exempt and so forth, as well as classification issues. Okay, we have 38 employees and 10 to 15 of those are parents. So we are concerned about potential changes to current FMLA that would require we pay them at 2/3 of their salaries for 12 weeks. I believe you said it would be partially funded by Social Security, but the line was cutting in and out. Did I hear correctly?
Yes, yeah. So the intention here is that employers would not be out any additional monies that they are not already paying into Social Security. So and the reason we didn't put it in a slide is because it's still kind of in flux right now. But what Mnuchin has said and what Pelosi has said and what the bill has proposed is that the Social Security Administration will be in charge of administering this law, that if you have monies already paid into the account, they will use that money to pay this leave, that if you do not have sufficient funds within your account to pay any sort of leave, that the IRS will actually advance that money, and that you will continue to make your regular payments into your regular Social Security payments into your IRS account. It won't be additional coming out of your pocket, and it won't be an increased amount. So it's something that will come out of what you're already paying for, and how the math will all work out is kind of a TBD. But it's going to be covered by what you're already paying.
Yeah, and going back to the question above, one quick second, just to jump up to, if an exempt employee starts the work week but only works one day, you have to pay the entire week. Like Kelly said, typically if you work during the work week at all, you typically pay that. There are some limited exceptions. So like she said, deal with your counsel, because there are specific delineated exceptions that might be applicable to that specific employee that's outside of the norm where you normally pay the full work week. So that's important to look into that. Okay, what if employees want to self-quarantine that do therapy services? Kelly had just about this, touched on this earlier. Currently, the benefits that are being proposed at the House level and through these acts, status quo applies, by the way, at this point. But if these acts do come in, they're very specific about when the paid sick leave applies, when the expanded FMLA applies, and so forth. And if you're outside of that, your current company policies would continue to be applied. So someone cannot unilaterally veer outside of the boundaries of what the law allows them to do from an FMLA time off paid leave, sick paid leave policy, or any existing company policy in place. They can't decide what they're doing and whatnot. You may, as a business, say, you know what, you do qualify under the FMLA, expanded FMLA, therefore we're going to deal with that. But once they come out with the criteria as to whether or not they're subject to that, you default back to your company policies that are currently in place. I suspect if they're self-quarantined, they may very well be subject to some of those benefits that are coming out in these new laws that are coming down the road. Currently, right now, obviously, if they have paid time off, earned paid time off, you're allowed to let them take earned PTO off. If they don't have any PTO, they can, and you decide, you know what, you're self-quarantined, good practice to allow them to take time off, even if it's unpaid, to be able to self-quarantine. That may change once the Senate and the President, and I suspect it will, but remains to be seen if that will change in the future. But currently, the existing PTO company policies and all of that still applies, as discussed earlier with Kelly. Okay, let me see what the next one is. I think we just discussed the last question about what payroll tax relief there is for companies experiencing impact from COVID-19. Wait and see. Nothing at this point. It should be coming and I suspect that we'll be getting more detail from from Mnuchin, as well as the Senate in the coming days. But that is what's discussed out there. They're trying to make the paid sick leave and the expanded FMLA more of the paid sick leave covered by the IRS and money back into the pockets of the employers to help muscle through this incredible time. However, there is no current benefit that is provided from a relief standpoint. Payroll tax relief specifically has not been decided upon, is our understanding. Trump had talked about payroll tax relief earlier, but payroll tax relief has shifted to other kinds of relief, which include money directly in the employee's hands. This IRS portion that Mnuchin and the Senate are working on to help deal with paid sick leave. Although Trump has stated payroll tax relief is something he favors, there has been a lot of literature out there that there's been discussion that they're veering away from payroll tax relief, but I wouldn't rule anything out of the question at this time.
Yeah, if you've been following this at all, so when the House passed the bill in the early morning hours of the 14th, most people thought it was going to go to the Senate immediately. The Senate kind of declined to take it up, saying that it wasn't a complete bill, and then I think they were kind of pressured into taking it up anyway. And so yesterday afternoon, Mitch McConnell said, you know what, I'm going to have the Senate vote on it. I'm going to tell the Senate they need to pass it, even though it stinks. I'm going to tell them to hold their noses and pass it anyway, because something needs to be done. But I have groups of people working together on passing a bigger, better bill, or putting together a bigger, better bill that's going to do more and do it better than this bill. And I think that's probably where we'll see more of those payroll tax relief sorts of things, because that's kind of a down the road,
Right.
or a devil is in the details type thing, where the House bill was more we need immediate relief for the employers, and to keep the employees who may be sick out of the workplace to stop this thing from spreading.
Yeah, and I think in the end, you're going to be hearing more about that. But as of late, I think it's been put a little bit more on the back burner. But I don't think it's a guarantee that it's off the table.
Yeah, I think it's going to be a part one, let's stop this thing from spreading. Part two, let's help the economy recover.
Yeah, it may even be a part 3 or 4. Hopefully we can resolve this sooner than later. Okay, I think that's all the questions. Carlos Saladriz, I'll turn it right back to you unless there's any further questions.
No, I don't see any other questions. Again, thank you so much, Carlos and Kelly, for doing this and putting it together so quickly, especially with the limited information we've got. Basically, what I'm reading is kind of what Kelly just said. The Senate looks like they're going to pass something today with a bigger expansion to come. So I think tomorrow, once this passes, hopefully we'll start getting a lot more information. To all our clients, thank you. Just know that all of us are here for you 24/7. Whatever you need, we're going to do everything we can to make sure that we provide you with information as quickly as we can digest it. Our goal is to, as soon as something does pass, as soon as we can figure out exactly what it means, is to have more webinars throughout the few coming days and weeks until we get through this. But again, thank you all very much. Please contact your HR representative, any of us, for anything you need. Thank you again, Carlos and Kelly.
Thank you all. Appreciate it. Thank you,
Thank
Regis.
you.
We appreciate it.